Greetings to you, ladies and gentlemen, and I trust you are well. And welcome to our lesson entitled Law of Contract. And we are going to be looking at the definition of a contract. We're going to be looking at the elements of a contract and when does a contract, or under which circumstances does a contract become invalid. Now in this chapter, ladies and gentlemen, we are going to be doing it in two phases because of its length, so that you can clearly understand it. And in addition to that, we are going to be making use of a number of case law. And it is quite important or pivotal for you to make use of that case law as well when you are answering in your examination. Yes, so we're going to be looking at the definition which Professor Christie, in his section on contract, which is a very important textbook on law of contract and how he defines it. And he provides a very simple definition and says that a contract is an agreement that is entered into with the intention of creating legal obligations. So the Bible in the book of Amos chapter 3 verse 3 says that how can two walk together unless they be agreed? And I think that's a very valid and important question, because if people are to walk together, whether it be in relation to a relationship, whether it be in relation to a marriage, whether it be in relation to a business, whether it be in relation to embark on a major project, those two people have to come together. And in addition to that, there has to be an agreement which will therefore flow from that very agreement entered into, and in addition it has to create legal obligations and then subsequently be binding in law. So there are three important features that really emerge from this definition. That number one, all contracts are agreements by definition. In other words, without agreement usually between two parties, there can be no contract. Ngamanye amagama, kufuneka kuvumelane abantu ababini ukuze lo contract okanye sisovumelwano si create a legal obligation. In other words, if it's only one party who says, look, I love you, I want to marry you, but the other party does not agree, there cannot be a legal agreement or legal said to be an agreement that is entered between those two people. Same applies if kukumntu oyi-one othengisa indlu, othengisa umhlaba, ayenze le deed of sale, assign lo omnye angasign, there is no legal agreement that exists between those two people. And then secondly, not all agreements create valid legal obligation, even if that is the intention of the parties. There are some principles of law which render purported agreements or at least unenforceable contracts. Are we together? So, ladies and gentlemen, it is going to become clear in other essential elements of a contract why we say that some of the contracts cannot create a legal obligation. For example, issues such as capacity, which we're going to be talking about. Umntu xa emncinci under the age of 18 years old, 2 10-year-olds cannot enter into a contract. Bangathi sebevumelene bengenile kulo contract leyo, that contract will not become valid. Or another contract which can occur between abantu abadala who died with that contractual capacity is a contract ukuthengisa umuntu uthi hayi ndidikwe ngulo mntana ndiyamthengisa, I am selling this child. That contract is unenforceable, ladies and gentlemen, because it is against the principles of legal justice. And then secondly, there must be an intention to create legal obligations, not simply moral or social obligations. So legal obligations is very important, ladies and gentlemen, because especially the aspect 80, it must have that intention to create those legal obligations. You can't simply do a contract for simply well-being or for simply value purposes. No, you must intend that if any of the parties do not abide by this particular contract, then there are legal consequences that can flow, whether it be the breach of a contract, which is a cancellation, or enforcing your rights and be able to claim it damages, or whatever emerges from that particular contract as to what the consequences of breach of contract are. So the intention, even with regards to marriage, marriage is a social and moral obligations, because you enter into this being within a contract to say we're going to get married, we're going to raise a child, and we're going to have children that are going to grow up with values and standard. To some, marriage may be a gateway for them to have sex. We're not able to sleep with each other because the Bible prohibits us from doing that. That is a moral obligation for you that you need to fulfill in order for that contract to be valid. But, ladies and gentlemen, that contract must create legal obligations. It's not sufficient for those particular reasons. It must be intended that these parties are bound by this legal relationship. They are bound by this legal relationship. And there are legal consequences if these parties both do not adhere to what they are required to do. I trust that we're still together. So let us look at the most important aspect, ladies and gentlemen, for or in a contract or in this chapter, ladies and gentlemen, right? The essential elements of a contract. Zezi zinto ezenza i-contract ibe yiyo. In other words, if ezizinto ke ayizizo, then that particular contract cannot deemed to be a valid contract, and all of these elements must be present. Okay, capacity for there to be a valid contract, certain essential elements need to be present, ladies and gentlemen. If one or more of these elements is missing, there will be no valid contract, right? It will be null and void. These essential elements are the following. Number one, contractual capacity. For a contract to be valid in law, the parties must have had the capacity to enter into a legal agreement. In other words, banalo na igunya lokungena kwesisivumelano ababantu bobabini. We are going to be looking at each of these elements in detail. Secondly, consensus. The element of agreement is fundamental to the element of the contract. Remember previously we said there must be an agreement between two persons. Akwazi ukuza umuntu one athi decide ukuthengisela wena lendlu. If the other party ayivumi ukuyithengisa lendlu, then there is no contract that exists between those two parties. And then the third aspect is the issue of illegality. The subject of the agreement must be legal. Mayibe semthethweni le contract. In other words, it must be permissible in terms of the law to enter into this contract. Number four, performance must be possible. The parties must be able to perform in terms of the contract. In other words, mayikwazi le contract, ladies and gentlemen, mayikwenzeke. Right? If there is an agreement that is entered into, then this contract, it must be possible. This contract must be fulfilled. Okay? Ungenzi ngoku into engenawuze ikwazi nje ukwenzeka. Are we together? We're going to go into detail into that. Formalities. There may be other formalities that may be imposed upon the contract by the parties or by the law, which must be complied with. Right? So zezike ngoku ozawuzifakela ngokwakho. Zezo zawuzifakela ngokwakho kulo contract leyo. Utsho ke ngokwena into yokuba In addition to as elements as E4, if you have other formalities that you have imposed, for example, it may be that for you to buy this house, then at least there must be the monies that are affected before this contract could be valid, right? There must be. See, these are is a suspensive condition, right? For this contract to be valid, so big suspensive condition city for this contract to be enforceable, for this sale to go through, is subject to a 30-day suspensive condition that this contract should abide by in order for it to be valid. Therefore, if that one is not prevalent, if that formality is not prescribed with, then that contract is invalid. Which is a capacity, right? So let us look at the first one. The ability to enter into a contract is known as a contractual capacity. It refers to the power to acquire rights and to incur obligations under a contract. The general principle is that any person is free to enter into a contract, subject to the provisions of law. In practice, however, the law limits the contractual capacity of certain persons and denies it completely to others. In depth or in detail. Let's look at categories of contractual capacity. So, people with full contractual capacities. These include men and women over the age of 18 years old and juristic companies, right? So if you are 18 years old, in other words, you are of the majority age, and then you run a company. Remember that in our previous lesson, when we spoke about the private law, we spoke about the juristic persons and their ability to be able to acquire rights and their ability to be able to, acquire rights on their own, being sued in their personal capacity. So those things, companies or Spa or Shoprite or Checkers have their own juristic personality. So they are able to enter into contracts on their own because they have a full contractual capacity. Same applies with Umdona 18 because she is of the age of 18 and above. But we have what is known as people with limited contractual capacity. These may only conclude contracts if they are assisted by other persons. These include minors above the ages of 7 years old and prodigals or insolvents. Where A exceeds his limited contractual capacity, the other party will be bound to the extent that that contract benefits A. A can then elect to enforce the contract or to abandon it. A will not be expected to perform in terms of a contract which is detrimental to him, right? So, ladies and gentlemen, this in a nutshell says that umntu oneminyaka eyi-7 nangaphezulu up to the age of 18 years old banento ekuthiwa limited contractual capacity. In other words, their capacity to enter into a contract will only be validated by them being assisted by someone who is at least older, who is above the age of 18 years old. That person may be their guardian or that person may be their parent, right? In order for them to enter into those contractual capacity. There's on this fun again no kugcwalisa iform yasesikoleni, because you may ask yourself, hey, be contracting ngeno 7-year-old. Kaloku xa ufunela umntwana esikolo ukusayinela la admission form to enter into that particular school, you are entering into a contractual agreement entered in between you and that particular school for the purposes of performance of giving that child an education. So the guardian or the parent is often the one who signs that contract. And lo mzali lo ubound ke lo contract. That's why xa kubizwa parents meeting kufuneka bepha or umntana kwezinye izikolo angagxothwa nogxothwa bomzali wakhe angezanga. That's why kusithwa the other party will be bound to the extent that the contract benefits, right? And then there are people with absolutely no contractual capacity. These include insane or intoxicated person and minors below the age of 7. Where such persons enter into contracts, their contracts will be void, the agreement will be of no effect. Okay? Umntu ophambanayo ogulayo, umntu onxilileyo, umntu aphansi kwe-age of 7 years akakwazi ukungena kwi-contract. If lo mntu lo ungenele kwi-contract enxilile ndibana phaa ethaveni, wena khawundithengele le ndlu, then it will absolutely mean that that contract will become invalid and will have no legal effect. Okay, so let us go into detail again about this aspect here agreement. Okay, the most critical element of a valid contract is the presence of consensus, right, or agreement. Agreement is reached when the parties come to a conscious accord on the specific content of the obligations they intend to create within each other. The general rule is that the agreement will be reached when one party accepts an offer made by another party. The key to agreement is thus the presence of an offer and acceptance. Okay, let us look at what uChristi kwincwadi yakhe Law Essay paragraph 129 defines an offer in the following way. An offer is a statement in which the offerer sets out the person to whom the offer is made, what performance and what term he is prepared to bind himself. The proposal is made with the intention that by its mere acceptance, a contract should be formed. So, ladies and gentlemen, in a nutshell, when we spoke about agreement, that for a contract to be valid, there must be agreement, right? And we go into detail now and say there must be an offer and an accepted. We have an offeree, the person Christi sets out to the person to whom the offer is made, what performance and what he is prepared to bind himself. Sithetha ke ngoku context yomuntu othengisa indlu. That's the only example that comes in my mind now. To the person who would be selling a house, okay, the person who would be selling the house, to say as an offerer, you are saying that le ndlu ke ndiyithengisa nge-500,000, okay, le ndlu inezi conditions. So what performance is expected for you is to give me that 500,000 within the period of 7 days. And what terms are you prepared to bind yourself to? That this house will be yours. Whatever thing, whether it be rates ezishiyekileyo, bekufuneka uzibhatalile, whatever happens, seyixhomekeke kuwe ngoku. Okay? The proposal is made with the intention that by its mere acceptance, a contract formed. For an offer to be valid, certain requirements need to be satisfied. An offer may be made to a defined person or to the whole world. The offer must be serious. This means that in order to qualify as an offer, the statement must be seriously intended to create legal obligations. We are saying this again and again, that the intention, ladies and gentlemen, for a contract, it must be that there must be legal obligations that are going to flow from this particular contract. So, for example, promises made in jest or anger or mere social arrangements would not qualify as contract of offers in law. Okay? Mhlekazi man, ndizakubhatala wena man, ndizakubhatala suwara man, sukwara ndizakubhatala masibhejo ba uwinile ubani ndizakubhatala ba uwinile umbhejo does not qualify because it does not create a legal obligation, right? I'm not talking about now a verbal agreement, please. There's a difference between those things. Verbal agreement, ukuthethwa, ungathi umuntu mhlawumbe umboleka imali athi ndizakubhatala akakubhatali, you can take that person to court on the basis of the verbal agreement that has been entered into. But what we're talking about here is that yinto nje ethethwayo kuba ufuna ubhejwa kusithwane, those things are not valid agreements. In fact, they do not constitute an offer insofar as Christa is concerned. The offer must be definite and complete. This means that for an offer to be valid, it must not be ambiguous, unclear, or mere negotiations. The contract, the offer must be clear, ladies and gentlemen, because we're still talking about an offer and acceptance now, insofar as it concerns an agreement. What we are saying here is simply that that offer must not be that's what we're talking about. Don't say into ambiguous. I go clear, right? We may be able to sell you this house should the tenant who is living there leave the house. That is not an offer. It's not clear, because because you may have to undertake a process to evict that particular person. Then what do you do then? Okay, so it must not be ambiguous. Secondly, the offer, or thirdly, the offer must be communicated to the offeree, right? The offerer must make or must communicate the offer to the offeree. No contract must be arise from a uncommunicated offer. Speaks for itself. So let's look at then the question that we may have to consider. Is an advertisement for an item at a specific price in a window shop a valid offer for the purposes of the law of contract? So we often see that insofar as it concerns shop they often advertise izinto that you may find that as figure paya, in actual fact usenokwenzeka kuba azikho, ziphelile, out of stock, or that might not be the true price. It was simply to just attract you. Well, that falls under a different scope legally. It in terms of our answer, does not constitute an offer. The leading case on this point is Crowell versus Rex 1909 TS 1105, where the court found that an advertisement in these circumstances is a mere invitation to do business. The offer is made by the customer when he or she attempts to pay for the item, and the contract is created when the shop accepts the offer. I repeat, the court found that an advertisement in circumstances were a mere invitation, it's a memo, right? The offer is made by the customer when he or she attempts to pay for the item, and the contract is created when the shop accepts that offer. If the advertisement were a valid offer, then a shop could be obliged to sell the item even if they ran out of stock. You remember what I spoke about in relation to stock, that there has to be an offer and there has to be an acceptance. In this case, you are the one that is making an offer to actually, buy that particular thing, and then the business accepts that offer. So the general rule is that a contract does not come into existence and until the offer has been accepted. Christie, our favorite author in law essay, paragraph 133, defines the concept of acceptance in the following way: that an acceptance is a statement of intention in which the offeree signifies his assent to the proposal embodied to the offer. Once again, before an acceptance will be valid, certain legal requirements will need to be satisfied. So we spoke about the offer. We said that it must be disclosed to the other person, so that he can be able to make an informed. It must be very clear. It must not be unambiguous. I'm going to look at the acceptance because it has its own requirements that need to be satisfied. The acceptance must be made by the person to whom the offer is made. A purported acceptance by anyone will also not create a valid contract. The acceptance must be made in response to an offer. It is legally impossible for a person to accept an offer which was not made to him. And now ndamkele umntu othi wenze isivumelano nam ndibe mna ndingayixelelwanga loo nto. Kaloku you are accepting in relation to what you have been offered. This the most clear example that comes to mind would be marriage. You find that in one of these Pentecostal churches, right? Uthe uzawuqala kumfundisi uthi ndiyayifuna le ntombazana ukuze uyithathe. Okay, that in itself is not acceptance, even if angahamba communicate, because kaloku there has to be the other party needs to be aware of this offer. That's why azawuda abizwe badityaniswe, right? So that amve umfundisi uba uyavumelana nani uba mtshate nalo mntu. The pastor himself cannot be able to accept. Are we together? So an acceptance must be unconditional, right? The acceptance must not leave room for doubt or require special interpretation. So it must be clear that you are accepting this offer. How is it clear? By signing and entering into that agreement that I, the undersigned, ban, do hereby agree to the terms as set out in the above mentioned contract, and I will abide by each one of them. So go clear again, there's no room that I will accept this contract provided that in or I may accept it can't of money. Nope, you have not accepted it. It's conditional. Okay, the acceptance must be communicated to the offerer. Right, we've spoken about that. Acceptance must occur in the prescribed manner. For example, an offer might require acceptance to be in writing, just as I have said to you, that under certain circumstances you are required to simply sign that agreement that indeed you are gonna go. But you need to actually draw an acceptance letter that you are actually accepting all, unequivocally accepting all the terms of this particular contract, and therefore you are going to be bound by it. I'm sorry, ladies and gentlemen, for this particular slide. I do not know what really happened here, because I tried to put everything on par. So let's look at another question that we might need to consider. When does a contract come into being where there is a delay between the offerer accepts the contract and when the offerer is aware that the offer is accepted? This happens when contracts are concluded via the post or the email. The answer to this question depends on which theory is used, and these theories differs really between post and email. So I'm going to be looking at the case of Cape Explosive Works versus SA Oil and Fed Industries, 1921. The judge president, they identified 4 possible theories that could be applied to postal contracts. The first being the declaration theory. The acceptance takes place when and where the offerer declares his intentions to accept. Example, by sitting and writing his letter of acceptance. That one is very clear. Okay, letter of acceptance. I accept. Number 2, the acceptance takes place when and where the letter of acceptance is posted. Okay, so as in terms of the expectation, as soon as the letter ithunyelwa via post, then that contract has been accepted. Okay, acceptance has taken place in terms of the expectation theory. The reception theory, the acceptance occurs when and when the letter of acceptance is delivered to the offerer's address. So in other words, in terms of the theory, as soon as it arrives to the offerer, as soon as it arrives at Northcrest, as soon as it arrives at Southridge, as soon as it arrives at Kwezi, then it becomes valid. And then the information theory, the acceptance occurs where and when the offerer reads the letter or becomes aware of their acceptance.